Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. It has been a whirlwind day. It's about 4 p.m. now as I record this. 9 a.m. this morning, I was 2 counties south of here, down at the government campus at the Washington State Supreme Court. We were arguing our magazine ban issue today, the matter of State of Washington versus Gators Guns. Come back here, doing a little geeking out, and lo and behold, there's a follow-up to this video right here. Now, we did this video over the weekend. We were out in Idaho when we shot it. Had to do with somebody who decided just to submit a pistol with an attached stabilizing brace to ATF for predetermination and was told that that absolutely positively was an SBR and therefore governed by the NFA. That had a lot of us wondering because we all thought, like, man, isn't that pistol brace rule dead? Well, that's what I thought too, but apparently the ATF didn't think so. That prompted some pretty swift action by the good folks over at the Gun Owners of America, and they have now received a letter in response to that, and it appears that the ATF, for the most part, is backing off that position. So let's get you all educated today, and let's talk about, does the ATF really know what they want to do with pistol braces? Okay, America, follow-up video. Wanted you to have all of the information. We did this video over the weekend, and it talked about how the ATF, for whatever reason, even though their pistol brace rule had been absolutely positively thrown out on its ass, we're still operating under it. Now, what they were claiming is no, we're just interpreting the federal definition of short barrel rifle to include all firearms with attached stabilizing braces. But of course, what was the premise behind the pistol brace rule? Well, it was exactly that. And court after court after court has put two behind its ears every time it's had an opportunity to review it. The rule, for all intents and purposes, is dead, and it's been nationally enjoined for months now. I thought I would never, ever, ever have to cover that freaking rule again, but here I am doing video number 2 in a week about it. Now, as I said in the previous video, Eric Pratt, Executive Vice President over at Gun Owners of America, as well as everyone over at GOA, had a complete conniption fit and sent a very terse letter to the ATF saying, hey, you know, what's up with this? Your rules has been shot down in this case, in this case, in this case, in this case. What exactly is going on here? GOA has received a letter back. I'm going to read that letter because it appears that the ATF is backing off a little bit. What it also appears is the ATF, shockingly, has no clue what they're talking about. Now, the letter received by GOA reads as follows. Mr. Pratt, this is a response to your email to myself and Bill Ryan dated January 6, 2025, and your letter to Assistant Director Megan Bennett dated January 9, 2025. ATF agrees that the statement, federal law requires a pistol with an attached stabilizing brace or stock to be registered as a short barrel rifle SBR, is overbroad. Okay, so that is really about the only backing off that we're going to get. Now we're going to get a lot of hemming and hawing and explanation from the ATF, which goes as follows. On November 8, 2023, the United States District Court for the Northern District of Texas stayed the final rule factoring criteria for firearms with attached stabilizing braces in its entirety, preventing further action in reliance on the final rule nationwide. The United States has appealed this decision. While the appeal is pending, ATF is complying with the court's order. How magnanimous of them, right? They are actually complying with the court's order. What else did the ATF have to say? The district court's order does not prohibit enforcement of the National Firearms Act, NFA, or the Gun Control Act, GCA. ATF remains responsible for enforcement of statutory provisions pertaining to a rifle having a barrel or barrels of less than 16 inches of length under the NFA and short-barreled rifles under the GCA. The statutory definition of rifle under the NFA and GCA includes, in relevant part, firearms with a rifled bore that are designed or redesigned, made or remade, and intended to be fired from the shoulder. A firearm designed and intended to be fired from the shoulder that meets the statutory definition of short-barrel rifle contained in the NFA must be made and transferred in accordance with the statutory requirements of the NFA. So I get that the folks over at GOA have said, hey, listen, the ATF has really backed off on this, and they certainly are watering down their statement. But then you read that paragraph and they're saying, well, no, we're still going to interpret the statute this way, and we still intend on enforcing it that way. Here's what else the ATF had to say. The Firearms Industry Program Branch, FIPD, diligently strives to analyze and provide the most current and accurate information and/or guidance to any inquiry made with our branch. We trust the foregoing has been responsive to your inquiry. Should you have additional questions, please contact us at, and then we'll go ahead and just leave that email address out of there, and then it is signed sincerely, Matthew Shear, Chief Firearms Industry Program Branch. Okay, so that's what you got right now. So, did the ATF back off of their position? A little. They basically said, well, yeah, we're not relying on the rule whatsoever, but they still doubled down on their same statement that, hey, listen, we still interpret the statute that way. We're still going to enforce the statute that way. And if we believe that this is a rifle with a barrel less than 16 inches, which is designed to be fired from the shoulder, we are going to act as though that should be regulated under the National Firearms Act. So what is my recommendation? My recommendation is everybody just hang on until January 20th, because I think there may be a much different attitude coming from the ATF moving forward. Okay, listen, we're going to go ahead and link up the information about the letter received by GOA down below. Hey, listen, kudos to all the people over at GOA. You guys got on this right away. You not only really very well represented your members, you represented gun owners nationwide. Thank you for that. And because of that, of course, we're going to put a link down below in the description box so that if any of you want to show GOA some love, you can do so. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, cool. Tell us all about it. Click on that link right there and let us know. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.